Hello viewers, today we are going to discuss very significant Honorable Supreme Court judgment with respect to Employees Provident Fund. It strikes at the basic understanding of wages that qualify for PF contribution. Before we move forward to decode the judgment of the Honorable Supreme Court, let's first understand the basic definition of wages under EPF Act and Minimum Wages Act. Under EPF Act Section 2B, basic wages means all emoluments. It's very clear. Earned by an employee while on duty or on leave or on holiday with wages, either in cash or in accordance with the terms of contract of employment. It is very clear. All emoluments, right? But there is exclusions. What are they? Cash value of any food concession, any dearness allowance, house rent allowance, overtime allowance, bonus, commission, or any other similar allowance. Third exclusion was the present. However, the dearness allowance and cash value of food concession is included under section 6, which talks about contribution, right? That there it takes basic wages, dearness allowance and food concession also. Now let's discuss what is the definition of minimum wages under the Minimum Wages Act. Section 2H of Minimum Wages Act defines wages means all remuneration. There all emoluments, all remuneration capable of being expressed in terms of money, right? Paid under terms of contract of employment. Yes, here also that is also the almost same for the work done. But there is an exclusion. What are the three exclusions? One, the value. What are the values? House rent, supply of light, electricity, water. Another value, any other amenities or services specifically excluded by the order of the appropriate government. That is the values that is excluded. In addition to that, any contribution to the Provident Fund or employee state insurance, any traveling allowance and value of any traveling concession. These three are excluded. So it looks almost similar. Then why there is a dispute? Now let's understand the judgment of the Honorable Supreme Court in light of the above two definitions. This is with respect to the Assistant Provident Fund Commissioner versus Group 4 Securities and Establishment. This pertains to a case related to 2009. It went to Appellate Tribunal, then it went to the High Court Single Judge, then it went to the High Court Division Bench, then it came to the Supreme Court, and finally in August 2023, the Supreme Court gave this judgment. You can see the long travel from 2009, that's almost 15 years. You can imagine the impact, right? So let's discuss further. The view of the Supreme Court, the Employees Provident Fund and Miscellaneous Provisions Act, Section 2B, we discussed. Once the EPF Act contains a specific provision defining the word basic wages, then there is no occasion for the appellant, that is the Provident Fund Commissioner, to expect the court to travel to Minimum Wages Act to see the definition and to give a different connotation of definition. This was the view of the Honorable Court. Now let's discuss the order. I'm going to discuss only the essence of the order, right? So what happened? The Assistant Provident Fund Commissioner, who was agreed by the order of the Honorable Division Bench of the Punjab and Haryana High Court, has challenged this order. Inter alia, this was an appeal against the order of the single judge passed in 2011. So what was the matter before the single judge? So before the learned single judge, the appellant has impunged the order dated 15 June 2009. The order passed by the appellate tribunal. This was challenged by the Provident Fund Commissioner. So the appellate tribunal, under the provisions of the Employees Provident Fund Act and Miscellaneous Provisions Act, held, while determining the issue raised by the respondent regarding the liability of the management. So who went to the appellate tribunal? Obviously, because the order was passed by the Assistant Provident Fund Commissioner under Section 7A, agreed by the order, the company went on an appeal to the appellate tribunal. So in the appellate tribunal, this was discussed in detail. The stand of the appellant is that for the purpose of determining its contribution towards Provident Fund, the respondent number one, who was the respondent number one? That is the company. The appellant was the Provident Fund Commissioner. He said the respondent, being the company, wrongly split the wage structure of the employees and treating the reduced wages as basic wages. He argued that the minimum wages was split into different components and was taken for the purpose of calculation. Thereby, the contribution was reduced. That was the argument placed by the Assistant Provident Fund Commissioner, because he was equating minimum wages with basic wages and then to determine the employee's contribution, thereby evading its liability. So he said that it was evading its liability. So under 7A, the order was passed by him. Okay, so what happened? So by reducing or bifurcating the wages, the contribution was reduced. This was the contention of the Provident Fund, Assistant Provident Fund Commissioner, and he passed an order. The also stand taken by the appellant has been turned down by the appellate tribunal. However, the appellate tribunal has turned down also by the learned single judge and the division bench of the High Court. That is why this appeal is with the Honorable Supreme Court. So in the Supreme Court, the learned additional Solicitor General submitted that for the purpose of determining the basic wages under the EPF Act, reference must be made to the definition of the expression minimum rate of wages under Section 4 of the Minimum Wages Act. This aspect has been considered in paragraph 6 of the impunged judgment and turned down. This was turned down, holding that there was no compulsion to hold the definition of basic wages to be equated with the definition of the minimum wages under the Minimum Wages Act. This was turned down by the Honorable Supreme Court also. The Supreme Court went on to say that in their opinion, once the EPF Act contains a specific definition, the word basic wages under Section 2B, there was no occasion for the appellant, that is the Provident Fund Commissioner, Assistant Provident Fund Commissioner, to expect the court to have travelled to the Minimum Wages Act. Don't expect the court to travel to the Minimum Wages Act, to give it a different connotation or an expansive, that is enlarged definition, as sought to be urged, because that was not the intention of the legislator. If that was the case, they would have said, please refer to Minimum Wages Act also. No, this is a specific act, because EPF Act is a special act and the basic wages is defined there. Then you can't take it to minimum wages. So it is also pertinent to note that a similar issue had come up for consideration in the order dated 2002, passed by the APFC under Section 7A of the Act. That was duly accepted by the appellant department. The department also accepted that. That was a different order, which was a contrary view to this, and the order was not challenged at all. So in view of the above of said observation, the present appeal is dismissed. That means you can't equate basic wages with minimum wages. In this case, for example, if the minimum wages is 15,000 rupees, if you have bifurcated the wages, basic wages as 7,500 rupees and balance 7,500 rupees, which you treated part as DA and part as HRA, then obviously the component of HRA, though if you put all the three components put together forms of minimum wages, cannot be taken into account. Thereby, the contribution impact will have a great impact on the PF contribution. It's a very, very important judgment. The Supreme Court had taken a very different stand as far as this particular case is concerned. Generally, they always wanted to give the benefit to the employee because it's a labor welfare, it's a social security cover, so the contribution also. But there were so many judgments which were different from this judgment, earlier judgments. That's why this judgment stands different, because once it is defined under the Act, you can't give a different connotation or enlarge its scope. Hope it's clear. Thank you. We'll see you in another video shortly.